I never thought a dirt road I inherited from my grandfather would turn into a legal battlefield that would make national news. But that's exactly what happened when the Meadowbrook Estates Homeowners Association decided they owned everything within a 5-mile radius of their precious development. My name is Carter Daniels, and I'm a 38-year-old software engineer who moved back to rural Oregon 3 years ago after my grandfather passed away. He left me his property, a beautiful 20-acre, spread in Deschutes County that backed up to the Cascade Mountains. The land had been in our family since 1952, long before the town of Bend became the hip outdoor recreation hub it is today. When Grandpa bought the property, it was just cattle ranches and empty high desert as far as you could see. The property came with something unusual, a half-mile private road that connected to Highway 97. Grandpa built it himself in 1954 with his own tractor and a lot of determination. Over the decades, that road became the only practical access point for a huge chunk of land that eventually got subdivided in the late 1990s into what became Meadowbrook Estates, a development of 63 homes ranging from $500,000 starter homes to $1-million McMansions. Here's where it gets interesting. In 2003, my grandfather, being the generous man he was, verbally told the developers they could use his road to access the back portion of their development. There was never a formal easement agreement, no recorded document, nothing in writing. Just a handshake and my grandfather's word. The developers, a company called Summit Ridge Development LLC, apparently never bothered to secure legal access to the northern section of their subdivision. They just built houses and sold them, assuming the informal arrangement with an elderly rancher would last forever. I didn't know any of this when I inherited the property. I was living in Seattle, working for Amazon, and dealing with the grief of losing the man who basically raised me after my parents died in a car accident when I was 12. The property came with a small ranch house, some outbuildings, and that road. I hired a local property management company to keep an eye on things while I figured out what to do with it. Everything changed on a Tuesday morning in March when I got a letter from the Meadowbrook Estates HOA. Not a friendly letter welcoming me to the community or offering condolences about my grandfather. No, this letter, signed by HOA President Patricia Whitmore, informed me that I was required to maintain the road to their standards, including repaving it, installing proper drainage, and adding streetlights. The estimated cost? $78,000. I read the letter 3 times, sitting in my cramped Seattle apartment, absolutely dumbfounded. They wanted me to spend nearly $80,000 improving a road on my own property so their residents could drive their Teslas and BMWs without hitting potholes. The letter went on to say that failure to comply within 90 days would result in the HOA placing a lien on my property for the costs of the improvements which they would undertake themselves. That's when I started digging into the property records. I drove down to Bend that weekend, spent 2 days at the county clerk's office, and discovered the truth. There was no recorded easement. The road was entirely on my property. The northern section of Meadowbrook Estates, where 63 homes stood, had no legal deeded access to any public road except through my land. The developer had somehow gotten the county to approve the subdivision without proper access, probably through some combination of incompetence and small-town politics. I contacted a real estate attorney in Bend named Michael Chen. He was a sharp guy in his early 40s who had handled several property disputes in the area. We met at his office on Wall Street in downtown Bend, a renovated historic building that still had the original brick walls. "This is remarkable," Michael said, spreading out the property documents across his conference table. "They've been using your road for over 20 years without any legal right to do so. In Oregon, they could potentially claim a prescriptive easement, but that requires open, notorious, continuous, and hostile use for 10 years. The problem for them is that your grandfather gave them permission, which negates the hostile requirement." "So what are my options?" I asked. "Well, you could grant them a formal easement, which would be the neighborly thing to do. You could charge them for it. Or," he paused, looking at me over his reading glasses, "you could revoke their permission to use your road. Since there's no recorded easement, you have every legal right to do so." The idea seemed nuclear. What would happen to those 63 homes? They'd be landlocked. They'd have to sue for access, probably claiming a necessity easement. But that could take years, and there's no guarantee they'd win. In the meantime, they couldn't legally use your road. I went back to my grandfather's house, which I'd started thinking of as my house, and sat on the porch watching the sunset paint the Three Sisters Mountains purple and orange. Part of me wanted to be reasonable, to work something out. But that letter from Patricia Whitmore kept burning in my mind, the arrogance of it. The assumption that they could just demand I spend my money to maintain their access. I decided to try the diplomatic approach first. I sent a letter to the HOA board explaining that there was no recorded easement, that my grandfather had only given verbal permission, and that I would be happy to discuss a formal easement agreement that would include cost sharing for road maintenance. I thought it was reasonable. I was wrong about what they'd think. 3 weeks later, I got a response. Not from Patricia directly, but from an attorney representing the HOA, a guy named Douglas Freeman from a firm in Portland. The letter was 5 pages of legal threats, claiming that I was attempting to extort the homeowners, that a prescriptive easement clearly existed, and that any attempt to interfere with their use of the road would result in immediate legal action. They demanded I withdraw my outrageous proposal and acknowledge their right to use the road free of charge. That letter arrived on a Friday. By Monday morning, I'd made my decision. I contacted Michael Chen and told him to prepare the necessary documentation. On Wednesday, we filed a formal notice with the county and sent certified letters to the HOA board and all 63 homeowners. The notice was simple. Effective in 30 days, permission to use the private road crossing my property was revoked. After that date, any use of the road would constitute trespassing. The reaction was instantaneous and explosive. My phone started ringing within hours. I didn't answer. Then the emails started coming, dozens of them. Some were pleading, some were angry, some were confused. A few homeowners sent reasonable messages asking to discuss the situation, but most followed the HOA's aggressive tone. Patricia Whitmore showed up at my door on a Thursday evening, 2 weeks before the deadline. I was having dinner when I heard her pounding on my door. I opened it to find a woman in her mid-50s with an aggressively styled blonde bob and too much makeup, wearing what looked like expensive athleisure wear. "You must be Mr. Daniels," she said, not waiting for an invitation before trying to push past me into the house. I blocked the doorway. "Can I help you?" "I'm Patricia Whitmore, president of the Meadowbrook Estates HOA board. We need to talk about this ridiculous stunt you're pulling." "I'm not pulling any stunt. I'm revoking permission to use my private property." Her face went red. "Do you have any idea what you're doing? There are families in those homes, children, elderly people. You're going to trap them with no way to get to their houses." "There are other ways," I said calmly. Michael and I had researched this. Theoretically, the residents could access their homes by driving through the adjacent property to the east, which would require crossing about 2 miles of undeveloped Bureau of Land Management territory. It would require a new road and permission from the BLM, but it was possible. That's absurd and you know it. That would take years and cost millions. Then I suggest you consider a formal easement agreement with proper cost sharing for maintenance. "We're not paying you a dime," Patricia snapped. "That road has been public access for 20 years. You can't just take it away." "It's never been public. It's always been private property, my property." "We'll sue you into the ground," she said. "When we're done, you'll wish you'd never heard of Meadowbrook Estates. Feel free to try. Please leave my property now." She stood there for a moment, her hands clenched into fists, her face contorted with rage. Then she turned and stomped back to her Lexus SUV, kicking up gravel as she sped away down my road. The deadline came on a cool Tuesday in May. I'd moved to Oregon full-time by then, having quit my job at Amazon. I had enough savings to live for a while, and honestly, the property dispute had become all-consuming. The night before the deadline, I hired a contractor to install a heavy-duty gate at the point where my road met the entrance to Meadowbrook Estates. It was a serious piece of equipment, 12 feet wide, 8 feet tall, made of steel pipe with a heavy-duty lock. At midnight, the gate went into effect. I installed security cameras covering the gate and the surrounding area. I wasn't naive enough to think everyone would respect it. The first incident happened at 7 in the morning. A guy in a pickup truck, later identified as Robert Morrison from 423 Meadowbrook Lane, rammed the gate with his vehicle. The gate held. The front end of his truck didn't. I called the sheriff's department and filed a trespassing and vandalism complaint. The deputy who responded, a patient young woman named Officer Sarah Rodriguez, took statements and photos. Robert Morrison was arrested and charged. By noon, there were 50 people gathered at the gate. Patricia Whitmore was there with a megaphone, leading what she called a peaceful protest, but which looked a lot like an angry mob to me. I watched from my security cameras as they chanted and held signs calling me everything from a greedy land baron to much worse things I won't repeat. The local news picked up the story that evening. A reporter from KTVZ in Bend called me for comment. I gave a brief statement explaining that I was simply exercising my property rights and that I remained open to negotiating a formal easement agreement. That interview made the evening news, and suddenly the story went regional. By the next morning, Portland news stations were covering it. The coverage was split. Some outlets portrayed me as a heartless property owner holding hostages. Others focused on the HOA's failure to secure proper legal access and their aggressive response to my reasonable requests. The comment sections were brutal on both sides. Meanwhile, the 63 homeowners were stuck. Several who worked in Bend were calling in sick or trying to work from home. Others attempted the alternative route through the BLM land, which required a four-wheel drive vehicle and took nearly 2 hours of off-road driving to reach the highway. One family tried it with a Honda Civic and got stuck in a ravine. Search and rescue had to pull them out. The lawsuit started flying. The HOA sued me for injunctive relief, asking the court to immediately reinstate access to the road. I countersued for trespass and harassment. Individual homeowners filed their own suits. Within 2 weeks, there were 7 different lawsuits working their way through the Deschutes County court system. The first hearing was set for 3 weeks after I closed the gate. It was an emergency motion by the HOA seeking a temporary restraining order to force me to reopen the road. The courthouse in Bend was packed. Michael Chen and I arrived to find news cameras and about 30 residents from Meadowbrook Estates filling the hallway. Judge Ronald Martinez presided. He was a no-nonsense guy in his 60s who'd been on the bench for 20 years. He listened to both sides present their arguments. Douglas Freeman, the HOA's attorney, argued passionately about the hardship to the residents, the danger to public safety, and the existence of an implied easement based on 20 years of use. Michael Chen countered with the property records, showing conclusively that no easement had ever been recorded, and argued that the permission my grandfather gave was revocable at any time. He also presented evidence of the HOA's threatening letters and their refusal to negotiate in good faith. Judge Martinez took a 10-minute recess, then came back with his ruling. I'm denying the motion for a temporary restraining order. The property records are clear. There is no recorded easement. While I understand the hardship this causes the residents, the law is on Mr. Daniels' side. The HOA and the residents will need to pursue their claims for a prescriptive or necessity easement through the normal legal process. In the meantime, Mr. Daniels has every right to control access to his private property. The courtroom erupted. Patricia Whitmore started screaming about corruption and judicial misconduct. The bailiff had to threaten her with contempt charges to get her to quiet down. Outside the courthouse, the news cameras swarmed me. I kept my statement brief. I've always been willing to negotiate a fair easement agreement. The HOA has refused every attempt at reasonable discussion. This situation is entirely of their own making. That night, someone threw a brick through my living room window. It had a note attached. "You'll regret this." I called the sheriff's department again. Officer Rodriguez came back out, looking tired and frustrated. "This is getting out of hand," she said as she photographed the brick in the note. "I've been getting calls constantly from the Meadowbrook residents. Some of them are making threats. Are you going to do anything about it?" "I'm filing reports. But between you and me, tensions are really high. You might want to consider some kind of compromise." "I've tried. They won't negotiate." She sighed. "Just be careful, okay?" I installed additional security measures, including motion sensor lights and more cameras. I also started varying my routine and keeping my truck in the garage. I wasn't paranoid, but I wasn't stupid either. The situation dragged on for weeks. The HOA residents tried everything they could think of. They contacted the county commissioners, demanding they use eminent domain to seize an easement across my property. The commissioners, after consulting with the county attorney, declined, saying there was no legal basis for such action. They contacted the state highway department, asking them to build a new access road. The highway department said it wasn't their jurisdiction. Meanwhile, the economic impact on the residents was mounting. Several families with children had to temporarily relocate to be closer to schools. Others were paying for helicopter services to ferry them in and out of the development. Yes, helicopter services. A few of the wealthier residents actually chartered helicopters rather than attempt the BLM land route. It was absurd and expensive, but it showed how desperate they were getting. The real estate values in Meadowbrook estates collapsed. Houses that had been worth $500,000 to $1 million were now essentially worthless. Who wants to buy a home with no legal road access? A few residents tried to sell anyway, listing their homes at 50% off. They got no offers. 2 months after I closed the gate, I got a different kind of visitor. His name was Andrew Richardson, and he lived at 387 Meadowbrook Lane with his wife and 2 kids. Unlike Patricia, he called ahead and politely asked if he could speak with me. I agreed to meet him at a coffee shop in Bend, neutral territory. Andrew was about my age, a lawyer who worked for a tech company remotely. He seemed exhausted, with dark circles under his eyes. "I want to apologize for how the HOA has handled this," he said, after we sat down with our coffees. "Patricia has been out of control. A lot of us tried to tell her to negotiate with you from the beginning, but she refused to listen." "I appreciate that," I said, "but it doesn't change the situation." "I know. And you're legally right. I've looked at the property records myself. We screwed up. The developer screwed up. But we've got 63 families trapped here, and most of them had no idea there was a problem when they bought their homes. That's not my fault. I know it's not. But I'm asking you person to person, what would it take to resolve this? What do you want?" It was the first time anyone from Meadowbrook Estates had asked me that question without hostility. I thought about it carefully before responding. "I want a formal recorded easement agreement. I want the HOA to pay half of all future maintenance costs for the road. I want a one-time payment of $20,000 to compensate for the years of use without permission and for the damage your residents have caused to the road. And I want a formal written apology from the HOA board." Andrew pulled out a notebook and wrote it down. "The money and the cost sharing are reasonable. The apology might be harder to get from Patricia, but I'll try. Can I take this back to the board?" "Please do." 3 days later, I got an email from Douglas Freeman, the HOA attorney. It rejected every single one of my terms and instead offered to grant me the privilege of donating the easement to the community in exchange for dropping all my counterclaims. I wasn't surprised, but I was disappointed. Andrew had tried. The story had gone national by this point. I did an interview with NPR about property rights and HOA overreach. The Wall Street Journal ran a piece about the situation as an example of problems in real estate development. I was getting interview requests from everyone from local podcasts to Good Morning America. I turned most of them down, but I did agree to a long-form interview with the Oregonian. That article, when it came out, was comprehensive and well-researched. The reporter, a woman named Jennifer Wu, had dug into the history of the development and discovered some interesting things. Summit Ridge Development LLC, the company that built Meadowbrook Estates, had a history of cutting corners on infrastructure. They'd been sued twice in other developments for similar issues. The company had dissolved in 2015, its principals having moved on to other ventures with different corporate entities. They'd left behind a mess, and the homeowners were paying the price. The article also revealed that Patricia Whitmore had personally invested in several properties in Meadowbrook Estates as rental properties. She owned 4 homes in the development, which explained why she was taking the situation so personally. It wasn't just about being HOA president. Her personal wealth was tied up in these properties that were now worth virtually nothing. After the article came out, I started getting more sympathetic coverage. People began to see the situation differently when they understood that the HOA president wasn't just fighting for her neighbors, but for her own investment portfolio. The legal process ground forward slowly. Depositions were scheduled, discovery requests flew back and forth. Michael Chen estimated we were looking at 18 months to 2 years before any of the cases went to trial. In the meantime, the gate stayed locked. Some Meadowbrook residents started moving out, walking away from their mortgages. The banks were furious. One bank, Pacific Coastal Savings, which held mortgages on 12 of the properties, actually filed their own lawsuit against me and the HOA, trying to recoup their losses. That lawsuit was dismissed quickly, but it showed how far the ripple effects were spreading. In July, 4 months after I closed the gate, I got a call from the Oregon Department of Justice. An assistant attorney general named Lisa Thornton wanted to discuss the situation. We met at her office in Salem, a 3-hour drive from Bend. "Mr. Daniels, I'll be direct with you," she said. "This situation is becoming a major problem for the state. We've got families trapped, property values destroyed, and a legal mess that could take years to resolve. The governor's office is getting calls about it." With respect, that's not my problem. I've offered reasonable terms for an easement. The HOA has refused. I understand, and legally, you're in the right, but we're exploring whether there might be a state interest in mediating this dispute. Would you be willing to participate in a formal mediation process? I thought about it. Only if Patricia Whitmore and the HOA board are willing to negotiate in good faith. I'll work on that. Can I have your commitment that if they agree to mediation, you'll participate? Yes. Lisa Thornton was apparently very persuasive. 2 weeks later, I received a formal invitation to a mediation session to be held in Bend, with a retired Oregon Supreme Court justice serving as mediator. All parties, including the HOA board, had agreed to participate. The mediation was scheduled for late August. It would be held at a conference center in Bend in a neutral setting designed to encourage productive conversation. Michael Chen and I prepared extensively, working out our bottom-line positions and our ideal outcomes. The day of the mediation arrived. The conference room was large, with windows overlooking the Deschutes River. The mediator was Justice Harold Kim, retired, a distinguished-looking man in his 70s with a reputation for fairness and patience. Besides Michael and me, there was the entire HOA board, which consisted of Patricia Whitmore, Andrew Richardson, and 3 other homeowners I hadn't met. Douglas Freeman was there representing the HOA. Lisa Thornton attended as an observer for the state. Justice Kim started with ground rules. Everyone will have a chance to speak. We'll keep things respectful. The goal here is to find a solution that everyone can live with. Let's start by having each party explain their position and their concerns. Patricia went first, and to her credit, she kept it relatively professional. She talked about the hardship on the families, the financial devastation, and the feeling that they were being held hostage over what she still characterized as a technicality. When it was my turn, I explained the history, my grandfather's informal arrangement, the HOA's aggressive demand that I spend $78,000 on improvements, and their refusal to negotiate. I showed the letters and emails documenting their threats and harassment. Justice Kim listened carefully, taking notes. After the initial statements, he separated us into different rooms and started shuttle diplomacy, moving between the groups to explore possible solutions. The mediation lasted 9 hours. It was exhausting. Patricia fought every point, but the other board members, particularly Andrew, were more reasonable. Slowly, painfully, we worked toward an agreement. The final terms were these. The HOA would grant me a formal recorded easement across my property. I would pay for half of any future road maintenance, and the HOA would pay the other half. The HOA would make a one-time payment of $15,000, representing partial compensation for past use. Each party would release all claims against the other and dismiss all pending lawsuits. The HOA board would issue a written statement acknowledging that they should have secured a formal easement agreement earlier and expressing regret for how the situation was handled. It wasn't everything I wanted, but it was fair. More importantly, it ended the dispute. At 8 in the evening, we signed the mediation agreement. Justice Kim looked relieved. Lisa Thornton actually smiled for the first time all day. I thought that was the end of it. I was wrong. The agreement required the HOA to make the $15,000 payment within 30 days and to get all 63 homeowners to sign off on the easement agreement, since they were all beneficiaries of it. The signed agreements and payment were due by September 25th. September 25th came and went. No payment, no signed agreements. I called Douglas Freeman, who sounded embarrassed. "There's been a complication," he said. "Some of the homeowners are refusing to sign. They're saying they never agreed to pay anything. They weren't part of the mediation. Their HOA board agreed on their behalf. That's how HOAs work." "I understand, but there's resistance. Patricia is calling another board meeting to discuss it." I felt the anger rising. "We had an agreement." "I know. Give me a week to work on it." That week turned into 2 weeks, then 3. I started getting rumors that Patricia was telling homeowners they didn't need to sign the agreement, that they should hold out for better terms. Michael Chen prepared to file a motion to enforce the mediation agreement. Then, on October 18th, everything changed. I got a call from Officer Rodriguez at the Sheriff's Department. "Mr. Daniels, I need you to come down to the station. There's something you need to see." I drove to the sheriff's office in Bend, wondering what was going on. Officer Rodriguez met me and led me to a conference room where a detective I didn't know was waiting. His name was Detective Marcus Webb. "Mr. Daniels, we've been investigating some irregularities related to the Meadowbrook Estates HOA. Are you aware that Patricia Whitmore has been collecting special assessments from the homeowners to pay for legal fees in this dispute?" I assumed she was. That's normal for an HOA. She collected over $230,000 in special assessments over the past 6 months, but the legal bills we've verified total only about $90,000. I stared at him. "Where did the rest of the money go?" "That's what we'd like to know. We've obtained financial records through a warrant, and it appears that Patricia has been transferring HOA funds to accounts controlled by her personally. We're talking about potentially $350,000 over the past 2 years. I sat back in my chair, stunned. "She's been embezzling from the HOA? "That's what it looks like. We're building a case, but I wanted to let you know because it affects your situation. The HOA may not have the funds to pay the settlement agreement because Patricia spent the money. This is unbelievable. There's more. We've also discovered that Patricia filed fraudulent insurance claims related to damage to the road, claiming that you or your agents had sabotaged HOA property. She collected about $40,000 from those claims. Detective Webb showed me copies of the insurance claims. They detailed supposed vandalism to parts of the road that were entirely on my property, claiming they were HOA common areas. It was fraud, plain and simple." "What happens now?" I asked. "We're going to arrest Patricia Whitmore tomorrow morning. We'll be charging her with embezzlement, fraud, and filing false insurance claims. I wanted to give you a heads up because this is going to create another media circus." He wasn't wrong. When Patricia was arrested the next day, the story exploded. Local news covered it live. The image of Patricia being led out of her house in handcuffs made the front page of the Oregonian and got picked up nationally. The story had everything: HOA drama, property rights disputes, and now white-collar crime. The homeowners of Meadowbrook Estates were devastated. Not only were their homes still landlocked, but now they discovered their HOA president had stolen hundreds of thousands of dollars from them. An emergency HOA meeting was called. Patricia was immediately removed from the board. Andrew Richardson was elected as emergency president. Andrew called me the day after Patricia's arrest. "Carter, I don't even know what to say. We had no idea she was stealing from us. The financial records she showed the board were completely fabricated." "I believe you," I said. "What are you going to do?" "We're trying to recover what we can from Patricia, but it looks like she spent most of the money. She was living way beyond her means. We're also trying to figure out how to move forward with the easement agreement. The problem is we don't have $15,000. We don't have any money." Patricia emptied the accounts. "What about the homeowners? Can you collect a special assessment?" "We can try, but morale is at rock bottom. People are barely hanging on financially as it is. Some of them are talking about a class action lawsuit against the HOA itself, against all of us who served on the board, even though we didn't know what Patricia was doing." The situation was a complete mess. I talked it over with Michael Chen and with my conscience. These homeowners had been victimized by Patricia's greed and by the developer's negligence. Yes, they'd been hostile to me, but a lot of that had been led by Patricia's manipulation. I made a decision. I called Andrew back. "Here's what I'm willing to do. I'll waive the $15,000 payment. We'll proceed with the easement agreement as written otherwise. The homeowners need to sign off on it and agree to the cost sharing for future maintenance. That's my final offer." There was silence on the other end of the line. Then Andrew's voice, thick with emotion. "Thank you. Seriously, thank you. I'll get everyone to sign, I promise." This time, he kept his promise. Within 2 weeks, all 63 homeowners had signed the easement agreement. We recorded it with the county on November 4th. The next morning, I opened the gate. I was there when the first car came through. It was a young couple with a baby, heading to work and daycare. The woman was crying. They stopped and thanked me, which was awkward and touching at the same time. Over the next few days, life started returning to normal for Meadowbrook Estates. People could get to work, kids could get to school without a 2-hour ordeal, and groceries could be delivered. The relief was palpable. Patricia Whitmore's legal troubles were just beginning. The Deschutes County District Attorney charged her with 7 felonies, including aggravated theft, fraud, and forgery. Her trial was set for the following spring. She tried to negotiate a plea deal, but the DA wasn't feeling generous. She'd stolen from her neighbors and lied repeatedly to cover it up. In March, Patricia pleaded guilty to 5 felony counts in exchange for the prosecution, dropping 2 others. She was sentenced to 5 years in prison and ordered to pay full restitution to the HOA and the insurance companies she'd defrauded. The judge, a different one than had handled my case, was harsh in his sentencing remarks. "You were in a position of trust," Judge Sarah Brennan said. "Your neighbors elected you to lead their organization, and you betrayed that trust in the worst possible way. You stole from them while they were facing a crisis, and then you tried to make their situation worse by refusing to negotiate in good faith with Mr. Daniels. Your greed and dishonesty have caused immense harm." I didn't attend the sentencing, but I read about it in the news. I felt no satisfaction in Patricia's downfall. Mostly, I just felt tired. The civil lawsuits took longer to resolve. The HOA and the homeowners eventually settled their suit against Summit Ridge Development's successor entities and the insurance companies that had insured the original title work. They recovered about $2 million, which was distributed among the homeowners to partially offset their losses. It wasn't enough to restore the property values to where they'd been, but it helped. I settled into life in Oregon. I'd started doing consulting work remotely, which paid the bills and gave me flexibility. The property became my refuge. I fixed up my grandfather's house, adding solar panels and upgrading the ancient plumbing. I started hiking the mountains he'd loved. I began to understand why he'd never wanted to leave. The road became a strange kind of symbol locally. News articles were written about it as an example of property rights, HOA governance gone wrong, and the importance of proper title work in real estate development. Law schools started using the case in their property law classes. I got invited to speak at a conference on land use planning, though I declined. Andrew Richardson and I became friendly, not quite friends, but cordial neighbors. He'd stepped down from the HOA board after 2 terms, burned out from the experience. We'd occasionally run into each other at coffee shops in Bend and chat about normal things like hiking trails and the weather. The first time I had to coordinate with the HOA on road maintenance was the following spring. A harsh winter had created some serious potholes and drainage issues. I contacted Andrew, who was still president at that time, and we worked out a plan. The HOA collected funds from the homeowners, I put in my share, and we hired a contractor to do the work. It cost about $12,000 total. My share was $6,000. I paid it without complaint. The work of maintaining the road became routine over time. We set up a formal road maintenance agreement that specified how costs would be split and how decisions would be made. It wasn't exciting, but it worked. The road was properly maintained for the first time in years. Property values in Meadowbrook Estates slowly recovered. It took about 3 years, but eventually, homes started selling again at reasonable prices. The new buyers all got very thorough title reports that clearly explained the easement situation. No one wanted a repeat of the previous disaster. I stayed on the property. Seattle and my old life felt like ancient history. I'd found something in Oregon that I hadn't known I was looking for, a connection to my grandfather, to the land, and to a simpler way of living. The whole nightmare with the HOA and the road had been traumatic, but it had also forced me to put down roots and fight for something that mattered. 5 years after I first closed that gate, I was sitting on my porch on a summer evening, watching the sunset, Color the mountains the same purple and orange I'd seen that first night when I decided to revoke the easement. A car came down the road, one of the Meadowbrook residents heading home from work. They waved as they passed. I waved back. My phone buzzed with an email. It was from a law professor at Lewis and Clark Law School in Portland, asking if I'd be willing to do a guest lecture about the case for her property law class. I smiled and started typing a polite decline. I'd told this story enough times. I was ready to just live my life. But then I stopped and reconsidered. Maybe there was value in sharing what I'd learned, not just the legal lessons about easements and property rights, but the human lessons about standing up for yourself, about not letting people bully you into giving up what's rightfully yours, and about finding ways to resolve conflicts even when both sides have dug in deep. I deleted my draft and started over. "I'd be happy to speak to your class," I wrote. "Let me know when works for your schedule." The gate across my road was still there, though it was never locked anymore except when I went on vacation. It served as a reminder of the property line, a physical marker of where my land met the easement. More importantly, it reminded me every day of what I'd learned during those intense months of conflict. I'd learned that being legally right doesn't always make things easier. I'd learned that communities can turn toxic quickly when led by the wrong people. I'd learned that most people are reasonable when you get them away from mob mentality and talk to them one-on-one. I'd learned that standing your ground can be exhausting and expensive, and worth it all at the same time. I'd also learned that my grandfather's handshake agreements and informal neighborliness came from a different era, one that didn't translate well to modern subdivisions and HOAs. His way of doing things had worked in 1954 when there were just a handful of ranchers in the area who all knew each other. It didn't work in 2023 when there were lawyers and HOA boards and property investors treating homes like commodities. The legal bills for the whole affair had been substantial. Even though I'd won and even though my insurance covered some of it, I'd spent probably $40,000 out of pocket on attorney fees. The stress had cost me too, in ways that were harder to quantify. But I'd also gained something valuable. Absolute clarity about my property rights and a formal agreement that protected those rights going forward. The HOA, for its part, had been completely reorganized. After Patricia's arrest and the financial scandal, the homeowners had voted to essentially disband the organization and reform it with new bylaws and much stronger financial oversight. They'd hired a professional property management company to handle the day-to-day operations and finances. The new board met quarterly instead of monthly and focused on essential issues only. One unexpected outcome was that several Meadowbrook residents actually thanked me once the dust had settled and Patricia's crimes had come to light. They told me that if I hadn't stood my ground, they never would have discovered she was stealing from them. The audit that was triggered by the mediation settlement had uncovered her embezzlement. In a weird way, my property rights dispute had saved them from even greater financial losses down the road. The insurance companies Patricia had defrauded eventually recovered most of their money through her restitution payments and by seizing her assets. Her 4 rental properties in Meadowbrook Estates were sold at auction. Ironically, because the road access issue had been resolved by that point, they sold for decent prices, and that money went toward her restitution obligations. I ran into Patricia's husband once at a grocery store in Bend, about a year after she went to prison. He looked like he'd aged a decade. He'd divorced her and moved to a small apartment in town. He told me, unprompted, that he'd had no idea what she was doing, that she'd hidden all of it from him. I believed him. He'd lost his home, his wife, and his reputation. I felt bad for him, even though part of me wondered how he could have been so oblivious. The media attention eventually faded, though the story would pop up occasionally as a reference point when other HOA disputes made the news. I got used to people in Bend recognizing me as that guy with the road for a while. Eventually, even that stopped, and I became just another resident of the area. I dated someone for a while, a woman named Rebecca, who worked as a park ranger for the Forest Service. She thought the whole road saga was funny in a dark way. "You're like the villain in a Hallmark movie," she joked once, "the mean property owner who won't let people use his road." We broke up after about a year, but it was amicable. She got transferred to a position in Montana, and neither of us wanted to do long distance. My consulting work continued to go well. I was making decent money, enough to live comfortably and save for the future. I invested in improving the property, adding a workshop where I could pursue a growing interest in woodworking. I built furniture and shelves and little boxes that I'd give to friends as gifts. It was therapeutic, working with my hands, creating things that would last. The road itself became almost beautiful in its own way. With proper maintenance for the first time in years, the potholes were filled, the drainage worked correctly, and the gravel was regularly graded. In spring, wildflowers grew along its edges. In winter, I'd plow it after snowstorms, and the HOA would reimburse me for half the cost. It was mundane and normal, exactly what it should have been all along. 7 years after I inherited the property, I was having coffee with Michael Chen, my attorney who'd become a genuine friend through the whole ordeal. We were talking about other cases he was working on, and he mentioned another easement dispute in a different part of the county. "Does it ever bother you?" he asked. "The way you'll always be associated with that case? The road guy?" I thought about it. Not really. I did what I had to do. I don't regret it. Even with all the stress and the cost and the threats, even with all that, my grandfather left me this property, and part of honoring that gift was protecting it, not just the land itself, but the rights that come with it. If I'd let the HOA push me around, I would have been betraying his trust. Michael nodded. "For what it's worth, I think you handled it right. You tried to be reasonable first. They're the ones who forced the confrontation." "I know, but I also learned that being right doesn't mean you won't pay a price." We finished our coffee and went our separate ways. I drove back to the property, passing through the gate that marked the boundary of my land. The road stretched ahead, solid and well-maintained, exactly as it should be. That evening, I got an email from Andrew Richardson. The HOA wanted to install some better signage on the road, marking the entrance to Meadowbrook Estates more clearly. They wanted to know if I had any objection and where the signs should be placed to make sure they were on the easement area, not on the part of my property outside the easement. I wrote back that it was fine, as long as the signs were properly placed. We exchanged a few more emails working out the details. It was boring, administrative, exactly the kind of normal interaction that should happen between an easement holder and the property owner. It felt like victory, in a quiet way. Looking back on the whole experience, I realized that the real lesson wasn't about property law or easements or HOAs. It was about knowing your worth and not letting other people define your rights or your value. Patricia Whitmore and the HOA board had tried to bully me into submission, assuming I'd cave to pressure and threats. When I didn't, when I stood firm and insisted on my legal rights, the whole house of cards they had built collapsed. If I'd given in to that first demand to spend $78,000 on road improvements, I would have set a precedent that they could make any demand they wanted. Patricia would have continued stealing, the homeowners would never have discovered it, and I would have been treated as a doormat to be walked over whenever convenient. Instead, by standing firm, by insisting on proper legal agreements and fair treatment, I'd forced everything into the light. It had been painful and expensive, but it had been worth it. The property became my home in a way I never expected. I'd started dating someone new, a teacher named Amanda who lived in Bend. We'd met at a community event, and she knew nothing about the road dispute until our third date, when I finally explained the whole story. She'd laughed and said it explained why I was so stubborn about making restaurant reservations the way I wanted them. I started thinking about the future more, maybe building a new house on the property, something more modern and efficient than my grandfather's old ranch house. Maybe getting involved in local land use planning issues, using what I'd learned to help other property owners navigate disputes. Maybe just living quietly and peacefully, enjoying the mountains and the high desert and the changing seasons. The road stretched out before me every day, a reminder of where I'd been and what I'd fought for. It was just a half-mile of gravel and dirt, but it represented something bigger. The right to control your own property, the importance of standing up to bullies, and the value of fighting for what's yours, even when it's hard. Every time I drove down that road, passing the gate that once was locked, I felt a sense of quiet satisfaction. I'd won, not just legally, though I'd won that too. I'd won the right to live on my own terms, to honor my grandfather's legacy, and to protect what was mine. That was worth more than any amount of money or any amount of peace and quiet I might have had if I'd just given in. The 63 homes of Meadowbrook Estates sat beyond the easement, their residents living their lives, their property values slowly recovering. They had road access, proper legal documentation, and a reformed HOA that actually worked for them instead of stealing from them. They'd paid a price to get there, in stress and lost property value in legal bills. But they'd also learned something about the importance of proper governance and oversight. As for Patricia Whitmore, she was serving her sentence at Coffee Creek Correctional Facility, the women's prison in Wilsonville, Oregon. I didn't think about her much anymore. She'd made her choices and she was paying the consequences. I hoped she was learning something from the experience, but that wasn't my concern. My concern was the property, the road, the mountains in the distance, and the life I was building here in Oregon. It was a good life, hard-won and deeply satisfying. The road that had caused so much trouble had become just another part of the landscape, properly maintained and legally documented, exactly as it should have been from the start. And every time someone from Meadowbrook Estates drove past my house using the easement that now existed in proper legal form, I was reminded that sometimes you have to fight for what's right, even when it's difficult, even when everyone tells you to back down, even when it would be easier to just give in. I didn't give in. I stood my ground. And in the end, that made all the difference.